Hello and welcome to the National Immigration Law Center's webinar on Understanding and Preparing for Administrative Relief. Thank you for joining us today. We're going to cover an overview of some of the President's recent actions on immigration. We have two presenters today, myself, Shumeen Shear from the National Immigration Law Center, or NILC, and Ignacio Rodriguez, also from NILC. So to start off, we're going to provide some background on what's been happening these past few years. There has been a lot of pressure from various immigrant rights organizations, ally organizations, and immigrant youth to pressure the President to stop deportations and provide protection for people who have extensive ties to the U.S. In response to a lot of this pressure and these actions, on June 15, 2012, the Department of Homeland Security issued a memo creating a 2-year deferred action program for young immigrants, which is called DACA. And on August 14, 2012, Immigration through the U.S. Citizenship and Immigration Services, or USCIS, released the application forms for the DACA program. So what is deferred action? DACA is a type of deferred action, and deferred action is based on a long-standing idea of prosecutorial discretion. This is the idea that immigration as a prosecuting agency has the ability to decide who to go after for deportations and also the power to stop deportations at any point. So with the DACA program, what we see is that deportations will be stopped for a certain group of people that meet a set of strict requirements. In addition to having their deportations stopped for 2 years, these people will also be able to receive work permits. Last year in November, the President made another announcement. His announcement included a series of widespread changes to the immigration system. There's several memos which outline these changes, and we've provided the links for you in the slide. These changes cover various aspects of immigration law, ranging from border security to support for high-skilled workers. For today's presentation, we'll focus on the two programs that provide protection for certain undocumented immigrants. These programs are known as DACA, Deferred Action for Childhood Arrivals, and DAPA, Deferred Action for Parents of U.S. Citizens and Lawful Permanent Residents. In terms of the number of people protected by these two programs, estimates are that nationally 4.4 million people who are parents of U.S. citizens and Lawful Permanent Residents, or LPRs, will be able to apply for the DAPA program. In addition, the President had announced an expansion of the existing DACA program, and this expansion will enable 290,000 more people to become eligible for DACA. We know that these numbers by themselves don't necessarily mean that everybody is going to come forward and apply for protection through these programs. With the original DACA program, the estimates were that 1.5 million people would be eligible, and so far we've seen over 600,000 people get approved. So this is where your role as a librarian is very critical, to share this information with people, encourage them to apply if they're eligible, and provide them with the information and referrals that they will need in order to be able to successfully apply. Our job is really cut out for us in Los Angeles. LA County has the largest number of people in the country in terms of people who are eligible for both the DAPA and the DACA programs. There's a total of 465,000 people in Los Angeles County who could potentially qualify for both of these programs. This is about half of the estimated undocumented population in our county. In terms of the benefits of these programs, they provide protection from deportation for a 3-year period. They also provide work authorization, which means that a person will be able to work legally with a work permit. A person will be able to receive a Social Security number, a non-AB60 driver's license, which means it's a driver's license that doesn't have a special marking, and they could also ask for permission to travel abroad. Some limitations of these programs are that they are not a green card or a visa. They also do not put a person on a path to citizenship. Again, these are just temporary programs. And as you might have heard in the recent news, these programs have been put on hold by a Texas judge. I should clarify that it's been expanded DACA and DAPA, the different announcements made by the President last November that are put on hold. The existing 2012 DACA program is still valid, and people can still apply for that DACA program. Also, there's been various attacks on these programs in Congress. So another limitation is that we do see that politically they're being challenged. In order to really convince people to apply for DACA, we've been sharing some of the results of surveys of people who have been approved for DACA. So one of these surveys from Harvard University showed that 59% of people who were granted DACA were able to obtain a new job, which often translates into increased earnings and also translates into people being able to better integrate into their communities by opening their first bank accounts and also by obtaining health care. So there's definitely many advantages and many benefits to receiving DACA. So I'm going to go over pretty briefly the DAPA program for parents. So you can see on the slide that there's several requirements for people to qualify for this program. Number one, people had to have lived in the U.S. continuously since January 1st, 2010. And as of the date of the President's announcement last year, they need to have a U.S. citizen or lawful permanent resident son or daughter. Also, people need to be physically in the U.S. on the date of the President's announcement through the time that they apply for DAPA, and they must be undocumented as of the date of the announcement. That means that they could have entered on a visa which later expired or have entered without documents and continue to not have any immigration status on November 20th, 2014. In addition, a person must not be an enforcement priority, which means that they can't have certain serious criminal convictions on their records. And in general, they can't have other factors in their case that would make immigration deny their application. So there's been a couple of questions about whether or not people are required to pay back taxes to apply for DACA, and the answer to that is no. People do not have to pay their back taxes in order to apply for DAPA. But we do expect that once people are granted DAPA and receive a work permit, that they begin to pay their taxes every year. So one question that many people often have is they're concerned that if they come forward to apply for DAPA or DACA, that they will get referred to ICE, which is the branch of immigration that deports people. So to provide people some reassurance, we usually tell them that USCIS does not refer their case for deportation unless it involves a criminal offense, fraud, or a threat to national security or public safety. There have been very few people referred for deportation as a result of applying for DACA, and that's typically only been people with serious criminal convictions. So if you do run across somebody who has concerns, you should definitely recommend that they first talk to an attorney or with a credible legal services program just to get reassured and to make sure that they receive a thorough screening before they apply for DACA. So we have two hypotheticals to reinforce what we just shared with you.
Maria and Brian entered the United States without inspection in May of 2007 and have never left. They have 2 children. Both children were born in the United States. Can Maria apply for DAPA? Maria has not had any contact with law enforcement.
So the answer to that is yes, she can apply for DAPA. She meets the requirements because she's been here since at least January 1st, 2010. She has not left the country since she came in, and she has 2 U.S. citizen children.
What about Brian? Brian had no trouble with the police, but he does have a final order of removal issued against him in 2010. He did not leave the U.S. after receiving this removal order. Is Brian eligible for DAPA?
So he is also. It doesn't matter if a person has a removal order as long as they meet the other requirements. So they could have been ordered deported and never left the U.S., or they could have been ordered deported and left the U.S. and came back. And as long as they came back before January 1st, 2010, they can still qualify for DAPA. And I just want to flag that this is not something where you should necessarily be giving people advice or telling them whether or not they qualify. This is one of those situations where if it's unclear whether or not they qualify, you should refer them to additional resources or to a local service agency, or you can refer them to NILC. We have a second hypo now.
Susanna has been living in the United States since 2000. When she entered without inspection, she has never left. She has 3 U.S. citizen children. Last year, Susanna was convicted of driving without a license, which is a misdemeanor in the state where she lives. Susanna has had no other trouble with the police. Is Susanna eligible for DAPA?
In this case, yes, she is, because immigration does not consider driving citations or driving infractions to be the type of crime for which a person would not be eligible for DAPA. So a person could have multiple driving-related tickets, and even if those driving incidents are charged as misdemeanors, they would still qualify for DAPA.
What if Susanna has a DUI conviction but didn't serve any time for this offense?
So in this case, this is an example of a person with a conviction, which is the type of person that you should definitely refer to a legal service agency. The rules actually do say that a person with a DUI is not eligible for DAPA. So unfortunately in this case, even though Susanna did not go to jail or serve any time in jail for this crime, she is not eligible for DAPA. So there's a lot of questions that people have about the DAPA program, and we don't know the answers to many of them yet. Many people might be step-parents of U.S. citizen kids, they might be foster parents, or they might have adopted a U.S. citizen child. We don't know yet whether these parents will qualify for DAPA. We also don't know when immigration says that a person has to continuously live in the U.S. since January 1st, 2010, what that means. It might mean that they could have left the U.S. for a period of time, such as a month or a couple of weeks. We're not sure yet. Third, we're not sure what the application looks like or when people will be able to apply for the program. Since the program is currently blocked by a Texas court, we don't know yet when people will be able to start applying for it. And finally, we're not sure yet exactly what documents will be accepted to prove that a person is eligible for DAPA, but we do have the DACA program to give us some ideas of what types of documents might be accepted. So we do know a few things about DAPA. One of them is that there will be a $465 fee. This will cover the cost of the work permit as well as the cost of getting fingerprints. We also know that people will have to go through a background check. So immigration will check if people have been arrested or convicted at any period of time. We know that for the most part, there's no way for people to get around paying this $465 fee. There will be some limited fee exemptions, most likely for people who are below the federal poverty line or people who are homeless or disabled. And we're not sure yet, as I mentioned, when exactly people will be able to apply. That will depend on what happens with the Texas versus U.S. case, which is the case where 26 states have challenged this program. We'll have to see what happens in that case in order to know when people can start to apply for DAPA. And the last thing we do know is that for the DAPA program, people, when they're approved, they will get deferred action, i.e. protection from deportation, and a work permit, also known as an employment authorization document, for 3 years.
Now that we have an understanding of DAPA, I will now discuss DACA, Deferred Action for Childhood Arrivals. In order to apply for DACA, each applicant must meet the following requirements: establish identity and age requirements, prove continuous residence for a certain period of time, prove physical presence on a particular day, meet the educational or military requirement, meet the criminal history requirement. We will now go over these requirements in more detail. In order to be eligible for DACA, applicants must establish their identity. At the time of filing, be at least 15 years old if they are not currently in removal proceedings, or can be 14 years old or younger only if they are in removal proceedings or have a final removal order or voluntary departure order and is not in immigration detention. An applicant must have been born after June 15, 1981 and have to have entered the United States before their 16th birthday. In order to be eligible for DACA, an applicant must have continuously resided in the United States since June 15, 2007 through the time of filing, have been physically present in the United States on June 15, 2012, that's the date of the announcement. Any exits outside the U.S. must have been brief, casual, and innocent. An applicant must have no valid immigration status on June 15, 2012. In order to be eligible for DACA, an applicant must show that they have graduated from a high school or obtained a GED or are currently attending school, or that they were honorably discharged from the U.S. Coast Guard or Armed Forces. For DACA, the Department of Homeland Security defines school as a public or private elementary school, junior high, middle school, high school, secondary school, education, literacy, or career vocational training programs that are designed to lead to a placement in post-secondary education, job training, or employment. They also define schools as education programs such as ESL classes, GED classes, continuation schools that assist students with getting a high school diploma or its equivalent under state law or in the preparation to pass a GED exam. An applicant for DACA must also disclose their criminal history if they have any. There are certain automatic disqualifications for certain criminal convictions. That includes all felonies, serious misdemeanors, which are listed there, more than 2 misdemeanors. There's also disqualifications for DACA if you are found to be 1, a public safety threat, or 2, a national security threat, which can be determined by participation in criminal activities, gang membership, expunged convictions, and someone who has a juvenile conviction. Please keep in mind that DHS will consider the totality of the circumstances when evaluating the application. And so if you meet anyone who has any contact with the criminal justice system, it's important for you to ask them to consult an attorney or a BIA-accredited representative before applying for DACA. I will now go over the requirements for expanded DACA. Expanded DACA is currently not available. It is not in effect because it is subject to the injunction that Shaming mentioned previously is applicable to DAPA. But just for your information, the program of expanded DACA creates a couple of changes. One, it eliminates the age cap to the current DACA process. So applicants do not have to have been born on June 15, 1981 or before or after in order to apply. It revises the eligibility entry date, and so that gets moved from January 15, 2007 to January 1, 2010. Also, DACA is for 2 years, whereas expanded DACA would be available for 3-year periods. And so both the deferred action and the EAD, known as also commonly known as the work authorization document, would be for 3 years. So expanded DACA was supposed to go into effect on February 18, 2015, but it was blocked by a Texas court. We do expect DACA forms to be revised to reflect these new changes. People eligible for DACA under the June 15, 2012 Napolitano memo should still apply for initial DACA and for renewal DACA. Now we will go over a series of hypos.
In the first one, Maricel from the Philippines is 17 years old. She entered the U.S. with a tourist visa in 2008 and has been in the U.S. since then, attending school. She wasn't eligible for DACA before. Is she eligible now?
Under the current DACA program, Maricel is not eligible because she doesn't meet the continuous residency requirement since 2007. She entered in 2008. However, if her tourist visa was expired at the date of the announcement and if expanded DACA goes into effect, then she would be eligible to apply for DACA.
Next, we have Paula from Mexico, who is 35 years old. She entered the U.S. without documents 20 years ago when she was 15, and she completed high school here. She was too old to qualify for DACA before. Is she eligible for DACA now?
Under the current DACA program, Paula would not be able to apply because she was 35 years old on the date of the initial announcement on June 15, 2012. However, if the expanded DACA goes into effect, she would be eligible to apply because the expanded DACA process does not have an age cap. Now I will discuss tips on how to prepare to apply. So what can potential DAPA and DACA applicants do now in preparation? First, they can start gathering evidence. They can also start saving money for the fees. They can avoid traveling abroad, as this could affect their continuous presence in the United States. And also, and most importantly, they should be on guard against fraud. In order to gather evidence to prove identity, a person should gather as many of these documents as they can. A passport from their home country, an ID card from their home country. These are things that you can go to the consulate to obtain. Birth certificates from their home country and photo ID. School or military ID with a photo. U.S. immigration documents with a photo and name. Acceptable documents showing relationship with U.S. citizen or legal permanent resident children include birth certificates of their child or children, a copy of the green card of the child, the naturalization certificate of the child, the adoption decree of the child if it's an adopted child, marriage certificate if it's a stepchild. In order to prove that the person has been continuously residing in the United States for the past 5 years and on November 20th, 2014, the date of the announcement, the person should start gathering rent receipts, rental agreements, utility bills, school records, which include letters, report cards, transcripts, military records, records from a religious organization confirming participation in a religious ceremony, money order receipts for money sent in or out of the country that have a date listed on them. Other ways to prove your presence for the past 5 years include passport entries, birth certificates of children born in the U.S., any kind of dated bank activity, car license, registration, insurance, DMV records, rental agreements, contracts, receipts, mortgages, tax receipts, medical records, and insurance. And again, it's important for all these documents to include dates. If someone has a criminal history, they can gather documents related to any contact they have had with the police or law enforcement. That includes the state criminal records, FBI report, and court records. Now I'm going to go over some slides regarding legal advice. Your role as a librarian is very critical as many people come to you seeking information and resources. And so when they come to you, it's important to ask them to be very mindful of the unlawful practice of law in order for them to avoid being victims of fraud. Please remind potential applicants of the following: that you are not giving them legal advice, that every case is different, that they should not take advice from a notary public or any immigration consultant. They should contact only a qualified immigration lawyer or a BIA accredited representative for legal advice on their case. So what is legal advice? Giving advice about any laws, whether they be local, state, federal law, or international, advising which forms to file with USCIS, advising what to do in a case. Who can give legal advice? Only lawyers licensed to practice in the state or federal courts can give legal advice and represent a person in court. Accredited representatives can represent people in immigration court. Notaries, public, paralegals, accredited representatives, and immigration consultants are not necessarily lawyers. So who cannot practice law? It is against the law for any non-attorneys to give legal advice. A non-attorney can only give non-legal help such as research, investigating details, translating answers to the questions on the DACA form, gathering supporting documents, and submitting the forms to USCIS. Here's a description of the California statute regarding the unauthorized practice of law. Any person advertising or holding himself or herself out as practicing or entitled to practice law or otherwise practicing law who is not an active member of the state bar or otherwise authorized pursuant to statute or court rule to practice law in the state at the time of doing so is guilty of a misdemeanor punishable by up to 1 year in a county jail or by a fine of up to $1,000 or by both that fine and imprisonment. So it's important to warn potential applicants of DACA and DAPA against these types of fraud.
And just to add to that, the reason we included the law was not particularly to scare anybody. What we're more concerned about, we're not so much concerned about whether somebody is going to actually pay a penalty or go to jail for giving legal advice when they're not authorized to do so. Our main concern is that the people who are potentially going to apply for these programs actually get legal advice from somebody who's entitled to provide it to them. We definitely don't want anybody who's not eligible to apply, particularly people with criminal issues who, if they apply, they could potentially face deportation. So the next section is just to quickly talk about people with DAPA and DACA's eligibility for health benefits. You might encounter people who are not only interested in applying for these programs, but also have questions about health care. So in terms of access to the Affordable Care Act, unfortunately, people with DACA and expanded DACA, once that program is available, will not be able to obtain benefits under the ACA or Affordable Care Act. This means that they can't actually access the marketplace to purchase a qualified health plan. It also means that they're exempt from the individual mandate to have a health care policy. We expect that the same is going to be true for people who ultimately are able to get DAPA, that they will not be able to get benefits under the ACA. So what does this mean? It means that people with DACA and DAPA will have to get coverage through the employer or buy their own coverage through Covered California. One thing to note, though, is that they can still apply for the ACA benefits on behalf of eligible family members, and they can be counted in the household for the purposes of size and income calculation. One alternative for people who won't be able to access the ACA is Medi-Cal, which, as you know, is a low-cost or free healthcare coverage. It provides access to different types of doctor visits, also medications, dental services, and vision benefits. So Medi-Cal is available to different groups of people, and in order to be eligible, people have to show that they meet the eligibility requirements, which include showing that their income is below a certain level. So for adults, this level is 138% of the federal poverty level, which is less than $33,000 a year for a family of 4. So if a DAPA or DACA recipient meets this criteria and other criteria, they will be eligible to get full-scope Medi-Cal under California law. We have different resources that we've listed on this page for you to look at in case you have other questions about these programs. The first one is the link to the NILC website, which has different FAQs and materials describing the President's executive announcement as well as the DACA program. The second link is to adminrelief.org, which also has various resources including PowerPoints and materials translated into different languages. And the last website is iamerica.org, which is fully translated into multiple languages. So if you encounter people who speak languages such as Spanish, Korean, Tagalog, they can go onto the iamerica.org and read all the materials in their native language. If you have any further questions as you encounter people who are eligible for DACA and DAPA, you can contact us. Our emails and direct phone numbers are listed on the slide.